The Convention on the Rights of the Child, in Article 1, states that a child means every human being below the age of 18 years, unless under the law applicable to the child, majority is attained earlier. In comparison, in Islamic law, a child is one who has not attained puberty. Once puberty is attained, the child is no longer a child, and this applies to both male and female. Puberty is attained with the physical ability to ejaculate in the case of males. For females, puberty begins at the commencement of menstruation. These physical developments, as is evident, vary from person to person. Information may not be available as to when a child passed on into the age of majority. Further, an act committed by a child, whether an offense or another, has always moved on into the past. Therefore, the existence of puberty at that particular moment of the commission of the act is very difficult to determine. To overcome this difficulty, the majority of the jurists across most schools of Islamic law adopted the presumption that the age of puberty for both males and females will commence at the age of 15. That is, anyone above 15 will no longer be considered a child. It was only Abu Hanifa who presumed that the age of majority for the male will be 18, and for the girl it will be 17. The presumptions will apply to intersex children as well. The presumptions are assessments by the jurists based on prolonged observation. To understand the rights of children in Islamic law, it is essential to look at the stages of a child's development since birth. In fact, it is instructive to examine the rights of the unborn child or the fetus as well. It has been elaborated in a previous video that all rights, liberties, and freedoms are granted by the Creator at birth. What about the unborn child? Does a fetus have rights? The Western system is not ready to acknowledge rights for an unborn child. The reason is that an acknowledgement of the rights of the fetus will lead to considering it as a life. This will affect the right of women to have abortions. Islamic law does give some rights to the fetus. It has the right to inheritance and to receive gifts. It was also given the right to freedom if the mother was emancipated. Islamic law fixes compensation for causing miscarriage, although this is less than the blood money for a living human being. According to some views, compensation is to be granted after the passage of a few weeks till such time that some limbs are formed. However, this does not imply that life begins at this age. Life begins at conception. The life of the child from birth to puberty is divided by some into two periods, from birth to the age of 7 and from 7 up to puberty. There is no criminal liability at all up to the age of puberty. The Hanafi jurists do not impose religious duties on the child either. Although it is considered good to introduce the child to various forms of worship around the age of 12, it may be pointed out that Western law, up until a few decades ago, held a child under 12 to be criminally liable depending on mental maturity. In British India, a child of 12 years could be awarded the death penalty under the Railways Act. In Islamic law, if a child who has not attained puberty has destroyed property or life, it will be held liable for compensation from its property, if any, that is, there is civil liability. For a child who has attained some form of mental maturity, there is no liability for contracts, unless the statements of the child have been ratified by the guardian, and these too are restricted to beneficial transactions alone. A child with mental maturity may sometimes be left to run shops in the father's absence because there is implied ratification. The guardian himself is allowed to undertake only those transactions on behalf of a child when these are beneficial for the child. The age of labor has been fixed by the International Labor Organization at 15 and 14 for underdeveloped countries. This coincides with the age of puberty in Islam. Therefore, a conflict is not visible. Once a child acquires actual physical puberty or passes the age of presumption of puberty, he or she is deemed an adult. Thus, once puberty is attained, the adult person can give free consent for marriage. According to the Child Registration Certificate, a child under 18 years of age is not free to give consent for marriage. Despite this, many countries in the West have fixed the age of consent for sex to be 14 or 15. Why not link it to puberty, we may ask? The person who has attained puberty is fully liable for criminal acts. He is also liable for all torts and for contracts concluded. In the case of financial matters and the handling of their property, the Quran has imposed the condition of rushd, or discretion. If a person has not attained rushd, that is, he or she is reckless with property, such a person may be placed under interdiction till the attainment of discretion. During this period, the guardian will manage his property. Abu Hanifa requires the removal of interdiction at the age of 25, even if the young person continues to be reckless. The reason is that in his view, by this age, the personal rights of an individual are more important than his property. Article 3 of the Convention deals with the best interests of the child. In Islamic law, this is a cardinal principle that is implemented from the birth of the child up to the attainment of puberty or majority. Thus, the custody of children, their upbringing and training, their property and all transactions in it are governed by the best interests of the child and its benefits. This is also the principle that courts follow in all decisions taken with respect to the child, especially the custody of a child after the parents are divorced. Article 5 deals with parental guidance. The third objective of the Sharia deals with the protection of the family unit, where the family is deemed essential for the rearing and training of children. Islamic law considers the care of the mother to be the best for a male child up to the age of 7, after which it prefers that the male be under the guidance of the father for acquiring manly skills and qualities. The courts also give importance to this principle. The articles dealing with freedom of expression and speech, education, the right to information and related matters are governed by the fourth objective of the Sharia, which protects and promotes the intellect. This objective can be seen at work throughout Islamic history, beginning with the translations of important works of other nations to the creation of so many great thinkers, philosophers, jurists and scientists who contributed to world knowledge and progress. The names of Avicenna, Algazel, and Averroes, among many others, are ample proof of this. Islamic law does not allow the adoption of children, so far as it amounts to passing on the name of the parents to the adopted child and granting them the right to inherit from such parents. This point became a serious issue at the time of ratification of the CRC by Muslim countries. And finally, as a compromise, the procedure of kafaalat or fosterage was substituted and accepted. This does not allow the foster parents to pass on their name to the foster child, nor does it entitle the child to inherit from them. To overcome this, it is possible for such parents to leave a bequest of up to 1/3 of their property to such a child. There is also a contract of walaa under which a binding agreement for mutual inheritance and other duties can be made between the foster parents and the foster child. But most people are not aware of this contract. On occasion, the Islamic law of inheritance is quoted as an example of discrimination against women, because a woman is given 1/2 of the share of a man. The system of the joint family and family duties imposes greater financial duties on a man as compared to a woman. To quote one example, a man gives a dowry to his wife, while a woman will receive dowry from her husband. There is, however, no need to be apologetic about these things, as some of the provisions are to be applied within a broader framework and not piecemeal. It is obvious that Islamic law will not permit certain requirements of areas like transgender laws, laws for gays and lesbians, and so on. In all fairness, we can see that Islamic law is a wise law as far as the child is concerned, and it does not suffer from some of the contradictions pointed out above for Western law.